Bruce Rivers, he's the criminal lawyer.
But who is he?
Bruce Rivers, he's the criminal lawyer.
And who is he?
Bruce Rivers, he's the criminal lawyer.
And what he do?
And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I am a board-certified criminal defense lawyer where I react to some rap cases, I react to some music, and today we are reacting to Kyle Rittenhouse, the trial of Kyle Rittenhouse. Now, Kyle Rittenhouse, as you remember, is a 17-year-old guy who was in Kenosha, Wisconsin, shortly after the shooting of Jacob Blake. Jacob Blake was shot. Didn't die, but there were a lot of protests that happened afterwards. Now, one of the things, and Kyle showed up with a medical kit, with an AR-15 and a fire extinguisher. He was on top of some buildings and acting as kind of a keeping the peace or protecting private property, which you cannot do with lethal force, by the way, unless it's your own home. We'll get into that in a little bit. But today they're starting the opening statements in that case. This is a case that's happening in Wisconsin. Now, Mr. Rittenhouse is charged with quite a number of counts. He's charged with first-degree reckless homicide, and the person that is on the first count is Joseph Rosenbaum, and we'll talk more about him in a little bit. First-degree reckless endangering safety, Richard McGinnis. Richard McGinnis was a kind of a reporter that was following Mr. Rittenhouse around. And then first-degree intentional homicide, that was the death of Anthony Huber. We'll talk more about him in a minute. Attempted first-degree intentional homicide of Gage, I'm going to butcher this name, Grosskreutz, and he attacked him and had a firearm on him at the time. And then first-degree reckless endangering safety of an unknown male. And then possession of a weapon by a person under the age of 18, which you're not allowed to do. Anyway, so today is their opening statements. And then we've gone over what an opening statement is. Opening statements are when you basically showcase the evidence. Now, I had a chance to watch some of the opening statements this morning, and vast difference between the defense and the prosecution. The prosecution did a traditional, the evidence will show, and did a kind of a very, probably maybe a 20, 25-minute summary. The defense, on the other hand, is doing something far different and really upset the prosecution, and they had a little motion hearing before it. The defense in this case showcased a lot of the exhibits that are going to be in this case. Almost made it look like the defense was more prepared. And I kind of think the state got a little out-lawyered in this aspect. So, you get up there and you just kind of give a brief summary, and then all of a sudden the defense gets up and showcases the entire case with video, with photographs, with basically a PowerPoint presentation. So what's going to happen here is once they get those done, those opening statements are done, then what happens is the state presents their witnesses. The defense has a chance to cross-examine the witnesses, and then the state would have an opportunity for rebuttal, and then they go into closing arguments. That's kind of the anatomy of a trial. Now, this is a case of self-defense. Now, there's a thing called, there's three basic precepts in any criminal case. There's the burden of proof, that rests with the government. So it's their case to prove. You have the presumption of innocence, and this will make more sense once I start talking about self-defense. But you're presumed innocent until proven guilty beyond a reasonable doubt. Not in the area of public opinion, but in a courtroom, that's a very fundamental precept. And then there's proof beyond a reasonable doubt. It's the highest standard in our judicial system. Now, we're going to react to this video, but I want to give you some framework about what we're dealing with here. What we're dealing with here is self-defense, okay? I'll just read it to you. self-defense is an issue in this case. This is the instruction. This is what the jury will hear at the end of the case. In deciding whether the defendant's conduct was criminally reckless conduct, which showed an utter disregard for human life, was a criminal reckless conduct, you should also consider whether the defendant acted lawfully in self-defense. Okay? The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent unlawful interference with the defendant's person, and the defendant believed that the amount of force the defendant used or threatened to use was necessary to prevent or terminate the interference, and the defendant's beliefs were reasonable at the time. Now, here's the thing. Remember I told you there's this presumption of innocence? Well, if the defense in this case gets a self-defense instruction, self-defense is presumed. And the state or the prosecution has to prove beyond a reasonable doubt that the defendant did not act in self-defense. Let me run that by you again. It's not that you have to prove you acted in self-defense. They have to prove that you didn't. And it has to be from the standpoint of the defendant at the time, not in hindsight, the jury looking back at the situation. So let's kind of go through what happened that night. When Kyle Rittenhouse, he was originally confronted by a guy last name of Rosenbaum. And Rosenbaum had just gotten out of a mental hospital for a suicide attempt. He was out on bond for domestic assault and had a no contact with, I think, his wife or his girlfriend. He was really outrageous in confronting Mr. Rittenhouse. And in fact, at one point, he can be seen saying, "Shoot me, shoot me, shoot me."
I'm giving everything you got. Shoot me, nigga. Shoot me, nigga. Bust on me, nigga, for real.
Think about the time that this is. The city's basically on fire, and everything is Kenosha, Wisconsin, so it's a smaller town. It's not like New York or Chicago or even Minneapolis, for that matter. But it's a smaller town. But still a big enough town that there's a lot of people in the street. There's destruction of property. There's your typical stuff going on. So the tensions are really high between the police and the protesters. But most people were protesting peacefully. But at some point, there's a confrontation between Mr. Rosenbaum and Mr. Rittenhouse. And it's unclear as to what the physical confrontation was. We'll show you that here in a second. But that happened in one part of the city, okay? And then after that happened, and Mr. McGinnis, who's this reporter, he's going to testify in the trial. He was there and saw what happened and was rendering aid after Mr. Rosenbaum gets shot, and then Kyle Rittenhouse takes off. And he's running down the street, and people start chasing him, and there's a few other confrontations, and that's where more shots ring out. So let's just kind of see what we're talking about here. So you see, okay, in the middle of the screen there, you can see the person that just ran to the middle of the screen. You see what looks like an old gas station boarded up, and the person with the gun there, that's Kyle Rittenhouse running away from somebody else. We don't know, and here's the thing. You can't use self-defense if you're the provocateur. In other words, you start a fight, you can't avail yourself of self-defense. You can revive it if you've retreated, but that's not what we have here. I mean, maybe we have that, maybe we don't. But we see him running away from the person that I think is Rosenbaum. See, in the reds, that red arrow points to Rittenhouse. And the red circle, that's Rosenbaum. And you can see he's chasing Rittenhouse. Rittenhouse is running away. So one of the precepts I love in self-defense cases is where the other party closes the gap. When you close the gap, so I'm running away from you, it puts me in a defensive posture. If I'm closing the gap, I'm the provocateur necessarily. So from this standpoint, just from a self-defense standpoint, it's shaping up nicely for Rittenhouse. And you can see there's a scuffle. There's something going on that is not all that visible in this from this angle, but the camera gets closer, and you can see there's Rittenhouse right there with he's got his medical bag in the back, and Rosenbaum is on the ground, and the guy in the shirt right next to him, that is McGinnis. So McGinnis takes his shirt off to render aid, and Mr. Rittenhouse is on the phone, and he's heard, I just shot somebody. So remember what I told you before? Some of these cases aren't really what happened. And I think that's going to be kind of the case in this. No one's going to say that he didn't shoot anybody. It's going to be, what does it mean legally? So you can tell that's him by all the identifying features, by the medical bag, by the shirt, and by the hat. So that's Kyle, and then Kyle decides to take off. Now, I am firmly convinced that whoever he's talking to on the phone told him to get the hell out of there. One of the things that the prosecutor raised in his opening statement was that he didn't render aid. That's always a red herring in a homicide case. If you're going to shoot somebody, you're going to help them? Probably not. And aid was already being rendered. So he runs down the street, down Sheridan Road, and that's where he has his next confrontation. So you can see Kyle's running down the road, and people are heard later saying, what did he do? And then he shot somebody. So they're trying to catch him, and he's running down really to go turn himself in. All right, now if we look at this first guy, he hits him, he knocks his cap off. But when one person does something like that, it sort of gives license to other people to chime in, right? And he's running away. He's running away from the prior scene. He's not going there to attack people. That's a different, totally different mindset than him going to attack somebody. So now you see all these people running after him. So, and here's the thing. I am not really taking a side. I'm just analyzing this from a criminal law standpoint, okay? These are such loaded and highly emotional times. If you remember, Minneapolis burned to shit, and it was just awful. It was a very scary time for our city, and I'm sure they're going through something very similar at the time. So now we see him there. Now he falls on the ground, and when he falls on the ground, he's confronted by a couple of things. One, he falls to the ground, but you also hear a gunshot go off. That's not his. It's somebody else shooting in the air. First, some guy kicks him in the face. And then the guy with the skateboard is trying to take his gun. And what are you going to do when somebody's take your gun? Is there a fear that they would use it against you? You're damn right there is. And if anybody's taken a concealed carry class, they tell you if they're going to take your gun, you use your gun. So the problem that I have with some of what he's on the ground and he's being attacked, and you've got the guy with the skateboard he gets shot in the shoulder, and then this Gage, he's got a gun on him. He has a firearm on him, and you'll see that here in this video. And he initially backs up, and we're gonna play this again and slow it down. Now watch. See, the one guy kicks him in the face. Then he's on his back, and he's being attacked by the guy with the skateboard. And and it may not be a deadly weapon, but it certainly is a weapon the way the skateboard's being used. And then, so the man with the skateboard gets hit, and then you've got Gage Grousowitz. And then what I don't like is he's got his hands up like this, and at some point Kyle puts the gun down, and it's at that point, it's unclear as to what's going on, but he fires that fatal round right then and there, and you're going to have to make the argument that he perceived him as a threat. He saw the firearm pointed at him and perceived it as a threat. That would be reasonable. If somebody's pointing a gun at you, you don't wait for them to pull the trigger. You pull the trigger yourself. So that's where the defense is going to go with this. And the way the defense has crafted these videos and put them all together was, I think, genius. See, I don't like this. This is a very bad picture for the defense, because the guy's got his arms up like this. That's a very submissive pose. But look where Kyle's gun is at that point. He's not pointed at him. It's pointed a little bit down towards the guy's knees.
What appears to be a handgun. The final shot is discharged.
And then he gets a little bit closer to him, and that's when the final shot. Now, as I told you at the beginning of this case, the parties are doing their opening statements, and the defense has creatively put together a montage of videos, and this is from that evening. In fact, this is all stuff that they probably got from the government. And generally speaking, you don't admit evidence, or you don't show the jury evidence that hasn't been admitted. That's kind of an old rule. It's not really even a rule, but that's just generally, if it's not admitted as evidence, or it's not going to be, you generally don't. The judge wouldn't allow it. But here's the deal: this is all stuff that came from the government. All this stuff is coming into evidence anyway. So if you're going to show them, this is what the evidence is going to show. And I think this is really brilliant from the defense standpoint. Now, let's kind of watch this montage. So you can see right there, there's Rittenhouse. See, they got a circle around it. And you can see him running. Or actually, he's not running at this point. This is the very beginning. And see what he says? He says, "Anybody need medical?" ? So that's what his mindset is. This is the danger we have when we demonize people. This is a kid. He went down there armed, but he also had a medical kit with him, and he's yelling out, "Does anybody need medical?" Medical. That's a totally different mindset than somebody that's out to kill somebody.
Trailer.
So you can see there's Rittenhouse right there.
Yeah,
These stupid white people. And you see them, tipping over garbage
They need
cans.
that trash can to put their garbage out. He's blocking the road.
Now, here's the other thing. So now we have a split screen, and this is from the defense. But that was an FBI camera, infrared, that shows the scene overhead. Ostensibly, I would assume it's in time with what we just looked at.
So now we're about further. That's it.
And see, and they switch back between high definition camera and infrared.
See a large crowd over here smashing the SUVs.
So there's Zeminski. I think his name is Josh Zeminski.
I think.
Okay, now here you have Rosenbaum and Kyle Rittenhouse entering the scene. So you've got Rittenhouse at this point. This is very early on. He's running down the street. You can see who he is. Now you see him running into the parking lot, and he's really being chased. Now, one of the things that the prosecution said early on is that Kyle Rittenhouse started this conflict, and they're just. And if you look at this screen, now we've got. I think we have three different views, and you can see that he's being chased. And so now Rosenbaum just threw a bag at him. Nothing really in the bag, it doesn't look like. It certainly wouldn't rise to the level of lethal force against him, but he is being pursued. And you hear a gunshot, but that gunshot is not Rittenhouse's gun yet. 1, 2, 3, 4. You hear that? That was Rittenhouse's gun. And what he does is he shoots Rosenbaum at that point. So that gives you kind of the beginning of how this thing unfolded. Now, when you have a self-defense case, generally there's a duty to retreat, unless you're in a stand-your-ground state. So you can reasonably think that you're in fear for your life. But a belief may be reasonable, even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. In other words, you can't look at it in hindsight and say, what a dumb shit, he should never have done that. You got to look at it from his standpoint. So he's going down there. He's saying, does anybody need medical? And he's got a medical kit with him. So that kind of gives you the context in which he's down there. And then you've got this guy, Rosenbaum, chasing him. And, I'm not sure if Rittenhouse knew of the prior statement. Rosenbaum says, shoot me now. And I think that was directly to Rittenhouse. So he knows the aggression that this guy has. And if that's the case, this guy does not have the boundaries and poses a significant threat. And Kyle Rittenhouse is running away from him. And remember what I said about closing the gap. He who closes the gap generally loses. And that's what happened in this case. Now, there's two other deaths, or two other victims of shooting, but one other death. Well, first of all, this is Zeminski. He fired a shot, and Rittenhouse's shots came 2.5 to 2.6 seconds later. So he hears the shot. He's being chased. What would a reasonable person think in those circumstances? Me personally, I would have stayed away from that whole area. But everybody was down there, and he was probably trying to do some good and whatever. And I'm not trying to defend him. I'm saying this is how the defense is going to paint this. And I'll be honest with you. I think he's going to win his case. I think Kyle Rittenhouse is going to get acquitted. But you have Zelensky firing that gun in the air. That frames him, all of a sudden you start to hear shots, and he's running, and he gets caught, and I don't know if they were struggling over the gun or what, but you hear the shots. And whether it was reasonable or not, after hearing what this guy said earlier, whether this would be reasonable is going to be something for the jury to decide. Now, the other one is this Gage Grosswitz. Let's kind of turn to his video made by Rittenhouse. So it'll be interesting to see how the rest of this evidence comes into play, because like I said, if you remember, self-defense is basically presumed if they get the instruction, and I believe they'll get the instruction. You only have to have some showing of self-defense, and he's being chased, he's being attacked. There's going to be and the question will just be whether what he did was reasonable. But the state has to disprove self-defense, that it wasn't reasonable. If they can't prove beyond a reasonable doubt that it wasn't reasonable, then Kyle Rittenhouse walks. Now, when they had jury selection last week, and I did find it interesting that the judge in this case had a situation where they had jurors who were sympathetic to the protesters, and those people were dismissed as for cause. Then they had people who, or at least one person, who was a very pro Second Amendment, and said, "I don't think I can be fair because I'm so pro Second Amendment." And the judge in that said, "Well, I don't give a shit about your." He didn't say, "I don't give a shit. I don't care about your Second Amendment views. I want to know about this, and this." And he didn't strike him for cause. So, but I guarantee you that guy's not sitting on the jury. I guarantee he's not sitting on the jury, because there's a thing called preemptory challenges. Two types of challenges. Challenges for cause, challenges for any or no reason. Those are preemptory challenges. And so if you can't get him off for cause, you can kick him off for any or no reason as long as it's race neutral. Okay? And so if the prosecutor has any smarts whatsoever, which I assume he does, he would have kicked him off the jury. So we'll see where this case goes, and we'll follow it, and we'll do updates later in the week. But it's my opinion that I think the state is out-lawyered. I think the defense is probably better prepared, and you're going to watch, I bet you any money, that he gets acquitted. That's just a guess. I could be wrong. The charges, I read you the charges. It'll be interesting to watch. So this has been another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board certified criminal defense lawyer. If you're watching this, you should sign up for Patreon. If you are watching this, you should sign up for, follow us on Instagram, Twitter, subscribe, like, follow, subscribe, do all that stuff. All the stuff you're supposed to do that I always forget to tell you to do all that stuff, because it helps our channel and it helps you, and I'm here to help you. So we'll see you next time on Criminal Lawyer Reacts.